Hi everyone! Welcome to my channel. Always remember, ignorance of the law excuses no one. This is Legally Engineer.
Kung hindi kayo satisfied, so you make a new agreement. Make a new agreement.
Yeah. Ang pag-usapan natin yan sa contract, kung yung possibility na baguhin mo yung original agreement, a new agreement, ganyan. Okay. So, alright, that's it. When it comes to fixing a period.
Yes.
Let's go to Article 1198.
Article 1198. So, the debtor shall lose every right to make use of the period. First, when after the obligation has been contracted, he becomes insolvent unless he gives a guarantee or security of the debt. Second, when he does not furnish to the creditor the guarantees or securities which he has promised. Third, when by his own acts he has impaired said guarantees or securities after their establishment, and when through a fortuitous event they disappear unless he immediately gives new ones equally satisfactory. And yung fourth, when the debtor violates any undertaking in consideration of which the creditor agreed to the period. And last, when the debtor attempts to abscond.
Very important provision ito, guys, Article 1198. Kasi again, the general rule is that before the arrival of the suspensive period, hindi mo pwedeng i-demand yan. But 1198 provides that there are cases when obligation can be demanded even before the lapse of a period. And again, the general rule is that you cannot do that, no? However, in these 5 circumstances na sinabi ni Attorney Oy kanina, the debtor shall lose every right to make use of the period. So, mawawala na siya ng karapatan na gamitin yung benefit of the period, which is for his
So it means the creditor can demand payment even before the maturity.
Yes, and in that case, the period is disregarded and the obligation becomes pure and therefore immediately demandable. So see, powerful tong provision na to. Biglang nagiging pure and demandable kahit naman may sinet na period. And the exceptions are based on the fact that the debtor may not be able to comply with his obligation. Isa-isahin natin to kasi baka ma-experience nyo to, no? Pag nangyari sa inyo. First is when the debtor becomes insolvent. Yan. So, ano nga ba ang
when the debtor becomes insolvent, yung state of insolvency, ano ba yun?
Ang isang tao ay insolvent kapag hindi siya makapagbayad ng kanyang mga obligasyon, ng pagkakautang at the time the obligation becomes due and demandable, or kaya naman he is in financial distress such that mas malaki ang kanyang liabilities kaysa sa assets na meron siya. In that case, that person can be considered as insolvent. Ikaw ba, Attorney? Insolvent ka ba ngayon?
Hindi pa naman. Hindi pa naman.
Sa ngayon, sa awa ng Diyos, hindi pa naman.
Hindi pa naman.
Dati madalas akong insolvent. Those are the dugyot days, no? Talagang hirap ng buhay. So, nangyayari talaga sa atin.
Oo, nangyayari yan sa atin.
Anyway, so, yan, nakaluwag-luwag po tayo ngayon.
Kaya mag-aral kayong mabuti.
Yes. To be like her. Okay, sige, example. Okay. The debtor owes the creditor 10,000 pesos due and payable on December 20. Okay. So may period? Yes, may period, December 20. Now, if the debtor becomes insolvent on September 10, so
but before the expiration, before the obligation becomes due and demandable,
3 months. 3 months bago mag-December 20, naging insolvent na siya. Now, my question, Attorney Uy, can the creditor demand payment from the debtor even if the period December 20 has not yet arrived?
Yes. So, ang gagamiting legal basis, Article 1198, Paragraph 1. The creditor can demand immediate payment from the debtor even before the maturity unless, sabi din dun sa first paragraph, the debtor gives sufficient guarantee or security. May exception.
Pwede naman kasi ngang, okay, hindi muna ako magbabayad. Halimbawa, ako yung debtor, siya yung creditor, tapos ako ay at the state of insolvency na nga. Pwede nga ba, i-promise ko sa kanya yung kotse ko as a guarantee or security.
Oo, worth, ano yun, mga 200,000 for example, yung utang.
Baka ganun. So,
December 31 pa yung maturity date. Pero on September 10, the debtor becomes insolvent. So, ang rule natin, me as the creditor can demand immediate payment from the debtor. So, pwede ako mag-demand sa kanya ng 200,000 payment unless the debtor gives sufficient guarantee or security.
In this case, kailangan ba merong judicial declaration na insolvent ang isang tao to avail of this remedy on the part of the creditor?
So, insolvency need not be judicially declared. It is sufficient that the assets of the debtor are less than his liabilities, or the debtor is unable to pay his debts as they mature.
And we should take note that the insolvency of the debtor must occur after the obligation has been contracted. Kasi kung prior pa naman sa pag-execute or contract nung obligation, hindi pa naman the creditor in that case actually takes the risk of extending. Nagpautang, alam mo namang insolvent na diba? So, you're taking the risk that case. So, let's go to the second case in here.
Yes.
That's when the debtor does not furnish guarantees or securities promised. So, ayun nga, halimbawa, nag-contract ng obligation si debtor and si creditor, napag-usapan nila na the debtors is supposed to give or furnish yung halimbawa collateral, guarantee or security because of that debt or loan. Tapos hindi naman niya pinifurnish nga kay creditor, hindi niya binibigay. Then in that case, pwede daw ma-avail itong remedy na to on the part of the creditor.
So he shall use his right over the period. So for example nga, nangutang ako kay Attorney Maralit ng 1 million, and kaya niya ako papautangin, it's because may bibigay ako sa kanya na collateral na house and lot. Tapos, ang sabi dyan, kung hindi ko, if I did not furnish the guarantee or the security that I promised, then Attorney Maralit can immediately demand the payment of the 1 million pesos.
Kasi na in that
even
case,
before the
pre-namis kasi ni Attorney O in that case na imo-mortgage yung house niya, parang to secure nga yung loan niya sa akin na in the amount of 1 million. Kung hindi niya i-mortgage yung yung house and lot niya na yun, I have the right as a creditor to right away demand the payment of the 1 million peso na amount ng loan, and she shall lose the right to avail of the benefit of the suspensive period na pinag-usapan natin dito. Okay. Now, the third one, Attorney, ano ba yung third?
is when the guarantee or securities given have been impaired or have disappeared.
Yan naman. So, kung kaya naman nagkaroon ng loan or ng utangan dahil sa isang security or guarantee, kasi itong security or guarantee na to ay na-impair or kaya nawala, nag-disappear. So, in that case, hindi na secured yung loan na meron tayo, and therefore, avail itong remedy na to. Halimbawa nga, if the debt is secured by a mortgage on the house of the debtor,
yun nga kanina, dun sa example, nangutang ako kay Attorney Maralit ng
1 million.
1 million, and then I furnish my house and lot as a collateral to the indebtedness. But my house was burned through my fault or negligence. So, the obligation becomes demandable. My obligation to Attorney Maralit becomes demandable unless I give a new security equally satisfactory.
So, take note of that. And in that case, yung sinasabi ni Attorney Oy dito, yung house niya, it need not be totally destroyed. Hindi kailangan totally burned down, no? As it is sufficient. Yes, it must be impaired. And it is sufficient that the security is impaired nga by the act of her or the debtor D. But in case of fortuitous event, halimbawa naman, kaya naman nasunog yung bahay na furnished as guarantee or security ay nasunog dahil sa fortuitous event, then it is required that the security must disappear. As in, totally burn down yung bahay na
may loss talaga.
Loss, yes. But if the security given deteriorates, alam mo, nag-deteriorate lang naman siya in such a manner as to become...
Because of the fortuitous event, nag-deteriorate lamang. So,
and it becomes illusory na in a way, because of the deterioration, then it must be deemed to have disappeared or lost as contemplated in paragraph 3 of Article 1198 of the new Civil Code. Okay. And if the debt is secured by a bond, kasi pwede naman kaya nasa-secure yung debt mo dahil nag-furnish ka ng bond nga doon sa creditor, the failure of the debtor to renew the bond or replace it with an equivalent guarantee upon its expiration will likewise give the creditor the right to demand immediate payment for it. Kasi pag nag-expire yung bond na yun, kailangan niyang i-renew to secure the debt or the loan na meron tayo. Okay? Pang-apat,
when the debtor violates an undertaking. So example, the creditor agreed to the period in consideration of the promise of the debtor to repair the piano of the creditor free of charge. So the violation of this undertaking by the debtor gives the creditor the right to demand immediate payment of the loan.
So, kaya nagpautang sa creditor.
Oo, kaya nagpautang sa akin si Attorney Maralit kasi sabi dyan, I will repair. I promise to repair his piano.
Free of charge.
Free of charge. Pautangin mo lang ako. But when I violated my undertaking to repair the piano, so it will make the obligation due and demandable.
Kasi in that case, kaya ako nag-agree as a creditor dun sa period for the benefit of the creditor C is the debtor D is because of in exchange of her promise na gawin niya yung aking piano free of charge for free. So the fact na hindi niya ngayon ginawa, then that is a violation of her undertaking, and therefore yung
kasi
period,
without that promise,
hindi
niya ako papautangin.
Hindi ko i-extend sa kanya yung period na yun as yet. So, therefore, mapo-forfeit na niya yung benefit of the suspensive period as earlier agreed upon by the two of us. Last one is when the debtor attempts to abscond. Yan. Ano ba yan?
So, before the due date of the obligation, the debtor changed his address without informing the creditor and with the intention of escaping from his obligation. This act of the debtor is a sign of bad faith, which results in the loss of his right to the benefit of the period stipulated. Also note that mere attempt or intent to abscond is sufficient.
So, halimbawa in that case, nangyayari ito sa totoong buhay, di ba? Nagtatago yung mga utang. So, pag nagtatago na sa inyo yung mga utang, that's papatak na yan sa paragraph 5, no?
It's a sign na ayaw na magbayad. So, sinilin mo na agad.
May nag-abscond siya. Halimbawa, magkapitbahay kami na attorney, pinautang ko siya, di ba? Tapos, madaling araw na narinig ko, nag-aaral sa balutan. Nag-aaral sa balutan si Attorney Uy. And then, I've heard sa usapan nila na wala nang planong bumalik ng si Attorney Uy. So, therefore, yung utang niya sa akin, paano yung mababayaran? So, alis na. Take two, hindi pa siya nakapag-abscond nun, mere attempt. So in that case, pwede ko nang puntahan siya at singilin siya right away, i-demand yung payment. Kasi sinabi nga dun sa explanation natin kanina, a mere attempt to abscond would mean forfeiture of the benefit of this suspensive period, no, the benefit of the same. So pwede ko na siyang singilin in that case. So take note of that as regards the topic of section 2, obligations with a period. Okay? So, now, papasok tayo dun sa section 3 of different kinds of obligations, particularly alternative obligations, and later on would be facultative obligations. So, Article 1199, Attorney Uy, ano bang sinasabi?
A person alternatively bound by different prestations shall completely perform one of them. The creditor cannot be compelled to receive part of one and part of the other undertaking.
And dito mahalagang pag-usapan natin kasi meron ditong at least two kinds of obligations, no?
According to object.
Yeah, according to object. So one of which is simple obligation and the other one is compound obligation. So let's start with simple obligation. Simply put, this is one where there is only one prestation. Halimbawa, si seller obliged himself to deliver to the buyer, let's say, a piano. No?
Isang prestation lang.
Yes, isang prestation lang yung meron, which is the delivery of the piano on the part of the seller. Halimbawa naman si seller si S promised to repair the car of B. So there's only one prestation, the promise to repair the car of B. So that is a simple obligation. Now, attorney, ano ba itong compound obligation?
Yung compound naman, one where there are two or more prestations. Two or more prestations. So, meron tayong, under ng compound, meron tayong conjunctive and distributive. Yung conjunctive obligation, one where there are several prestations and all of them are due.
Lahat.
Dito naman sa distributive, two or more of the prestations is due. It may be alternative or facultative.
Okay, so at least two or more ng mga prestations dapat ay due. Yan yung sinasabi natin na alternative 1199 or facultative under Article 1206.
Yes.
So ano ba ang meaning ng alternative obligation in the first place? An alternative obligation is one wherein various prestations are due but the performance of one of them is sufficiently determined by the choice which, as a general rule, belongs to the debtor. So may choice. So for example, si debtor, nang hiram siya kay creditor ng 10,000 piso. It was agreed that the debtor could comply with his obligations either by giving the creditor 10,000 pesos or instead of paying 10,000 pesos, give the creditor a colored television set or by painting the house of the creditor. See, there are three options on the part of the debtor.
Tatlo na yung prestations.
Bayaran mo. Tatlo yung prestations, no? Bayaran mo yung 10,000 in cash or magbigay ka ng color television set or painting the house of C. So, in this case, the debtor has the option, tama ba?
To choose.
To choose.
Kung alin doon yung i-deliver kay creditor.
So, pag nag-deliver ng 10,000 o kaya nag-deliver siya ng television set, color television set, or pinintahan niya yung bahay ni creditor, sufficient na yun to comply with the obligation.
Yes, so the delivery of one of the prestation will be sufficient.
And the performance must be complete.
Yes, hindi pwedeng, sige, 5,000. Out of 10,000, 5,000 lang. Tapos yung painting, yung kusina lang, ang pipintahan.
O kaya kalahati ng TV.
Oo, yung television set, yung antenna lang.
Di
Or
pwede
remote
yun.
lang.
Kasi in that case,
Ibig sabihin ng performance must be complete. Ibig sabihin, kapag mamimili si debtor na i-deliver niya kay creditor, dapat kung 10,000, 10,000. Kung television set, buong television set. At kung painting of the house, painting of the house. Hindi pwedeng
partial.
Oo.
Hindi pwede yun. Kasi mag-establish din yun ng co-ownership. And that is discouraged in this case. Okay? Now, let's proceed with Article 1200. No? The right of choice belongs to the debtor unless it has been expressly granted to the creditor in relation to 1199, no? As regards the right of choice. And the debtor shall have no right to choose those prestations which are impossible, unlawful, or which could not have been the object of the obligation. So, ilay down nga natin, Attorney Uy, yung right of choice as a rule. No?
Yes. So, as a general rule, the right to choose the prestation belongs to the debtor. By way of exception, it may be exercised by the creditor only when expressly granted to him or by a third person when the right is given to him by a common agreement.
Malino naman, ang general rule, ang right of choice ay nakay
debtor. So, ibig sabihin, even if without express mention, kung sino mamimili, si debtor, ang default. Pag may agreement lamang, if there's an express agreement na si creditor ang may right to choose, di si creditor or yung third person kapag both the creditor and debtor consented or agreed.
Right, so for example, Attorney Oy, si D, in-insure niya yung bahay niya, let's say with R, and R is an insurance company. And it is agreed that if the house is destroyed or damaged, si insurer R may either pay the damage or loss or reinstate or rebuild the house. So there are two possible prestations here to be performed by the insurer. One of which is bayaran na lang niya kung ano yung damage or i-repair or gawin niya yung bahay na damage, no? And since in this obligation or in their agreement, nothing is said in the as to who has the right to choose, then who has the right to choose?
Then, according to Article 1200, Sabi, si debtor has the right to choose.
And in this case, the insurer R would have the right either to pay the damage or loss or to reinstate or rebuild the house. The creditor D, the creditor nga, si D in this case, cannot choose kung ano ang gagawin ni insurer or ni debtor kasi nga wala namang express mention na siya ang may karapatan.
Kung ang nakalagay siguro dun sa contract is R may the creditor may either or the debtor may either pay the damage or loss or reinstate or rebuild the house at the option of the creditor. O
So,
di ang
nagbago
creditor
na
na.
Kung
And
ano
tandaan
prestation.
dapat expressly granted kay creditor.
So again, kapag hindi expressly granted kay creditor ang right to choose as to what prestation will be performed, the general rule applies, it is the debtor that has the right to choose. The right of choice of debtor again is not absolute. Bakit naman attorney?
And then yan dun sa last paragraph ng Article 1200. Because the right of choice of the debtor is subject to limitations. Una, the debtor cannot choose those prestations which are impossible, unlawful, or which could not have been the object of the obligation. Because these prestations are void, their presence do not invalidate the obligation if it includes other undertakings, otherwise free from such defects.
In other words, under Article 1200, the debtor's right of choice is not extinguished altogether but limited to the remaining valid prestations. Kasi nga, kung may several prestations ka dyan, tapos may ilan dun sa prestations na impossible, such as when they are illegal or unlawful, then the obligation itself will not be void. It's only the prestation that will be void. And again, the debtor cannot has no right to choose which is unlawful or impossible prestation. How about when it comes to the debtor? Pwede bang mangyari na yung debtor ay wala ng right of choice?
Yes. The debtor has no more right of choice when among the prestations whereby he is alternatively bound, only one is practicable.
Yeah. So it comes with a practicability kasi in this case, there is not only a limitation but a loss of the right of choice belongs to the other. The obligations become simple na kasi
salitang kanto, no choice ka na.
Wala kang
You have to
choice.
comply kung ano na lang yung natira.
Halimbawa, may tatlong prestations. Yung isa, physically impossible. Yung pangalawa, legally impossible. So, in that case, wala ka ng choice. isa na lang. Isa na lang yung yung pipiliin mo doon. So, such that yung alternative, may loss of rights as regards the right of choice belonging to the debtor, and yung alternative obligation mo becomes a simple obligation. Kasi isa na lang yung practicable prestation na pwede mong gawin. Okay.
Ito pa yung limitation. Sabi nga natin kanina, performance must be complete. So the debtor cannot choose part of one prestation and part of another prestation.
Self-explanatory, na-explain naman natin yun kanina. Bawal ang partial performance. Dapat complete performance. Let's go straight to Article 1201.
So the choice shall produce no effect except from the time it has been communicated.
Importante dito yung communication of notice that the choice has been made because again, una, ano ba yung effect of notice? Until the choice, sabi nga sa 1201, until the choice is made and communicated, the obligation remains alternative. So, nangyayari pala dito, Attorney Oy, na yung alternative, it becomes simple kasi kapag na-elect.
May nakapag-choose, tapos may communicate.
Nagiging, ano na siya, tawag, simple obligation. Okay. So, ano bang requirements dyan? Una, once the
notice of the election has been given to the creditor, the obligation ceases to be alternative and becomes simple.
Simple na yan. And such choice, once properly made and communicated, is irrevocable and cannot, therefore, be renounced. The concurrence of the creditor to the choice is not required. Okay. So, once na mag-express na ng choice itong si debtor, hindi pwedeng salawakan.
It has been communicated.
At na-communicate na yan, irrevocable na. Bawal yung unong sulong.
And you also do not, or the consent of the creditor to the choice is not required.
Kasi nga, it pertains to the, to the debtor. And it would be absurd kung, kung subject to the approval yan ng creditor. Di parang baliwala lang din yung right ni debtor dyan, di ba? And where the choice has been expressly given to the creditor, anong mangyayari, Attorney Uy?
Such choice shall likewise produce legal effects upon being communicated to the debtor. So, same lang. Kailangan din kapag either parties, kailangan if you selected your choice, you have to communicate or to give notice to the other party.
Yes, and that's as regards the effects. But as regards the proof and form of notice, meron ba? Meron bang required?
Yes, so the burden of proving that such communication has been made is upon him who made the choice.
So it should be the debtor, generally. Kung siya yung
debtor.
The law does not require any particular form regarding the giving of notice.
So it may be oral, in writing, or expressly or implied.
Okay, so take note of that. Now, Article 1202 provides that the debtor shall lose the right of choice when among the prestations whereby he is alternatively bound, only one is practicable. Ito yung pag-usapan natin kanina, no? Pag-iisa din ang practicable. And if more than one is practicable, it is Article 1200 that will apply kasi alternative obligation na nga yan. Meron kang choices eh. The obligation is still alternative because the debtor still retains the right of choice, no? Under Article 1202 naman, if only one is practicable, for example, the other prestations have become impossible, then the obligation is converted into a simple one. So take note of that ha, kung ano mag-a-apply.
Dahil na-convert na siya simple one, naging immediately demandable or demandable at once.
Take note guys kung ang mag-a-apply ay Article 1200 or Article 1202. Kapag may choices ka na mag-a-apply, Attorney Uy,
1200.
Alternative. Pag naman wala ng choice dahil nga iisa na lang ang practicable, anong applicable?
So 1202.
Yan. And it becomes
immediately demandable.
Kasi simple one na yan, simple obligation. Okay, so let's proceed with Article 1203.
So if through the Creditors' Acts, the debtor cannot make a choice according to the terms of the obligation, the latter may rescind the contract with damages.
So, sino ang hindi makakampan dyan? Si debtor, hindi siya makagawa ng choice niya. At
through the Creditors' Acts.
Kagagawa
Because of the fault of the creditor.
So, pwede na daw niyang i-rescind or i-cancel.
With damages.
Okay. Rescission, guys, take note that it creates the obligation to return the things which were the object of the contract together with their fruits and the price with its interest.
Yes.
And again, it is the very nature of an alternative obligation.
But the debtor can make his choice without the consent of the creditor. Hence, the right given the debtor to rescind the contract and recover damages if through the creditor's fault he cannot make a choice according to the terms of the obligation. Yun. The debtor, however, is not bound to rescind. So, hindi naman sinasabi dyan na the debtor shall rescind. The debtor is only given an option to rescind. Option lang, kung gusto lang niya. Hindi i-rescind niya with damages. Tandaan nyo, dahil may fault, dahil ng true creditor's fault, kaya may damages under Article 1170.
Yan, in relation to Article 1170. And permissive toll, may kasing ginamit na term. So, yun hina-highlight na Attorney Uy, hindi naman talaga siya hindi naman mandatory.
Oo, hindi naman mandatory na pagka may ganon, you rescind with damages.
So, for example, si debtor, nang hiram siya kay creditor ng, let's say, 20,000 pesos. And it was agreed that instead of 20,000 pesos, they could deliver, let's say, item 1, or item 2, or item 3. So, first question, is that an alternative obligation under Article 1200? The answer is yes, because there are 3 prestations other than the delivery of 20,000 pesos.
Yes, may several prestations, pero the compliance of one of the prestation is sufficient.
So, if for example, in this case, if through the fault of the creditor, let's say yung first item is destroyed, si debtor can rescind the contract kung gusto niya. No? Pwede ba yun? Kasi meron pa namang item 2 and item 3, Attorney Uy.
Kasi under Article 1202,
Yes.
Pwede. Yun ang legal basis. Pwede niyang i-rescind if he wants. And in case of rescission, the amount of 20,000 pesos must be returned by D with interest. So, kailangan magbayad ni D ni debtor ng utang na 20,000 pesos with interest. And yung creditor who is at fault must pay D the value of item 1 plus damages.
Take note. Kasi rescission yan eh. So, ibabalik nga kung anong nakuha.
You restore.
Restore.
Or you return what you receive.
Yes. So, since in this case, ang nawala yung item 1, edi magbayad si creditor.
Ikaw si debtor. So, on the part of the debtor, di ba may utang siya kay creditor? Ang gagawin ni debtor, dahil sabi niya gusto niya rescission with damages. So, ibabalik niya sa akin yung 20,000 pesos. With interest pa. Tapos ako naman, si creditor who is at fault, I am bound to pay the value of item 1 plus damages because of my fault.
So you have to weigh kung anong mas magandang option
kung
sa'yo.
saan ka mas makakalaki.
Yes. So, what if naman si debtor, instead of rescinding the contract, pwede ba niyang piliin na lang yung item 2 or item 3, Attorney Uy?
Yes. So, D or the debtor, instead of rescinding the contract, ito naman another option. Kung ayaw naman niya mag-rescind, he may choose item 2 or item 3 with a right to recover the value of item 1 with damages. Mas maganda to. Makukuha mo na yung value ng item 1 plus damages, tapos makakapamili ka pa dun kay item 2 and item 3. So, tatlong makukuha mo. Mas maganda to. Huwag mo nang i-rescind na lang.
Yes, tama naman.
Mas practical. So, yan. If the debtor chooses item 1, his obligation is extinguished. The creditor is not liable for damages. Ito naman, parang may payment na dito.
Kasi,
imbis na bayaran niya yung 20,000 pesos na utang, wala na lang, piliin ko na lang sa item 1 para extinguish yung utang ko magbayad.
Wala rin
yung payment of interest.
Wala rin namang payment of damages on the part of the creditor. So, these are options available to the debtor in the example given to us. No? So, take note of that. Now, Article 1204, it provides that the creditor shall have a right to indemnity for damages when through the fault of the debtor, all the things which are alternatively the object of the obligation have been lost, or the compliance of the obligation has become impossible. The indemnity shall be fixed, taking as a basis the value of the last thing which disappeared, or that of the service which last became impossible. Damages other than the value of the last thing or service may also be rewarded. Awarded. Yes, awarded.
Awarded.
Yes.
So, yung Article 1204 naman, talks about the effect of loss or becoming impossible of objects of the obligation. So dito naman sa Articles 1203 and 1204 apply when the right of choice belongs to the debtor. Under Article 1205, the creditor has the right to choose. So dun sa 1203, parehas silang sa 1204 na ang right of choice pertains to the debtor. Sa 1203 lang, the thing was lost due to the fault of the creditor. Dito naman sa 1204, the thing is lost through the fault of the debtor. One of the things.
All the things.
Dito, all sa 1204, all the things which are alternatively the object of the obligation have been lost.
So, in that case, ang rule natin dito, hatiin natin. Kung ang nangyari ba ay some of the objects ang nawala or all of the objects ang nawala.
Yes.
So, dun tayo sa una, kapag some of the objects or the prestations ang nawala,
or have become
impossible even through the fault of the debtor, then the debtor is not liable since he has the right of choice and the obligation can still be performed. Okay? And this is an exception to the general rule established in Article 1170 regarding liability for damages arising from negligence.
Because under Article 1204, may sinabi na through the fault of the debtor. So sabi natin, pag may fault under Article 1170, may liability for damages. Pero ang sabi dyan, this article is an exception to the general rule. Walang liability for damages ang debtor kahit nawala yung isa sa mga bagay, some of the objects, which is the object of the prestation, object of the obligation rather. Kung nawala man yung ilan doon through the fault of the debtor, tandaan na hindi liable for damages ang debtor. Why? Because the debtor has the right of choice.
And anyway, kahit naman nawala yan, kung hindi yun yung piliin ko, di ba? So, ang gusto kong piliin ay yung existing. So, there's no harm. Pero, what if naman all of the objects na ang nawala? Ano na mangyayari? If all of them have been lost or have become impossible through the debtor's fault, then the creditor shall have a right to indemnity for damages since the obligation can no longer be complied with. Of course, if the cause of the loss is a fortuitous event, then the obligation is extinguished.
So, ito yung kaibahan. You will distinguish kung ang loss is of all the objects is due to the fault of the debtor. So, dito na, papasok yung liability for damages. And kung if all the objects were lost through the fault of the debtor, yun nga, liability for damages.
Kasi hindi naman ko-comply obligation. Diba?
So, ganon. So, kapag naman, if all is lost, or if all are lost through fortuitous event, so you follow the general rule, the obligation will be extinguished.
In that case. So, for example, si S, nag-agree siya to deliver, let's say, item 1, item 2, or item 3. Then, if item 1 is lost through the fault of S, he can still select either item 2 or item 3 kasi he has the right of choice. Then, the loss of item 1 and 2 with or without the fault of S will reduce the obligation to a simple
isa na lang.
Kapag isa na lang. Pero pwede pa rin kasi
sa kanya may right, siya kasi pang may right of choice.
At saka naging simple one lang siya, pwede pa rin ma-comply ang obligation.
So paano naman kapag if all items are lost through his fault?
In that case, the liability will attach. Kasi alam natin na hindi na mako-comply ang obligation and therefore in that case, si creditor would have the right to indemnity na from the debtor. And kapag naman yan ay nawala lahat dahil nga sa fortuitous event, sabi natin the obligation will be extinguished. Okay. What's the basis of indemnity here, Attorney Uy? Bakit may right si creditor for the indemnity kapag ang lahat ng prestations ay nawala due to the debtor's fault?
So, ang basis or ang value ng indemnity shall be fixed, taking as basis the value of the last thing. Ayan, yung tanong mo kanina. The value of the last thing which disappeared or that of the service which last became impossible. In case of disagreement, it is incumbent upon the creditor to prove such value or which thing last disappeared or which service last became impossible. Other damages may likewise be awarded.
So ang basis ng matatanggap ni creditor as part of the indemnity,
kung all the prestations or loss or become impossible. So you will ascertain muna kung alin ba yung pinakahuli. Last, lagi yung last. Save the best for last. Save last. Tignan mo na.
Last thing or last service.
Diba, it is incumbent upon the creditor kung to prove kung alin yung pinakahuling nawala. Siyempre, ang interested ang creditor to prove na yung nawala, yung pinakahuling nawala, yung pinakamahal. Para mas malaking makuha niya. Pero in case of disagreement nga, yun, ang creditor will prove.
The creditor shall prove the value of the last thing that disappeared na kanyang nagiging basis for indemnity. So, halimbawa, dun sa example na binigay natin, di ba, meron tayong item 1, item 2, and item 3. If items 1 and 2 are lost, then in that case, si S will be bound to deliver item 3. Alam natin yan, magiging simple obligation na lang, right? Nawala na yung dalawang prestations, isa na lang, simple obligation, deliver item 3, si debtor not liable as yet for damages. But if subsequently item 3 is also lost through the fault of S, then the basis for indemnity is what? The value of item 3. Kasi yun yung huling nawala. At malinaw yung sinasabi ng batas dyan. The last thing or service that disappeared shall be the basis for indemnity. And the liability of S, again, is not affected, although the loss of items 1 and 2 was through a fortuitous event in that case. So, halimbawa, di ba tatlo nga yun? Yung item 1 nawala dahil fortuitous event, na burn, nasunog, halimbawa, tapos yung isa naman, let's say, bumaha. So, dahil pa rin sa fortuitous event. So, walang kasalanan dyan si debtor. Pero yung pangatlo, nawala dahil sa fault na meron siya. Ang sinasabi ng batas dito, despite the fact na fortuitous event ang cause ng pagkawala ng items 1 and 2, the fact na yung last item na nag-disappear ay due to his fault, liable pa rin siya sa damages. At ang indemnity is on the basis of item 3 which last disappeared. No?
So if item 3 is lost through the fault of S, his obligation is extinguished and he shall not be liable for damages although the loss of items 1 and 2 was due to his fault. O, yan naman yung baliktad. Basta ang magmamatter lang dyan, yung last item which was lost. And the creditor has the burden of proof.
So, ang nangyari dito, yung items 1 and items 1 and 2 nawala dahil naman sa kasalanan niya. Okay? Tapos yung pangatlo nawala.
Fortuitous event, so
extinguished. Hindi na magmamatter yung fault niya.
Bakit kaya, Attorney Maralit, lagi nating titingnan yung panghuli? Oo, yung huling item na nawala.
Kasi tatandaan nyo nga na may right of choice kasi nga siya. So kung kasi hodang nawala yung item 1 and item 2, kaya pa rin naman ma-fulfill yung
kasi
yung
kung nawala yung item 1 at saka yung item 2, the obligation is converted into a simple one. Isa na lang kasi yung i-comply na.
So kaya nag-a-attach lang yung liability kapag pati yung panghuli na nga, yung last thing or service ay nawala na din.
Yes.
So, check, ang simple lang yan check mo kung bakit nawala yung panghuli na possible. Kapag yan ay by the fault of the debtor, liability attaches. Kapag fortuitous ang reason ng pagkawala ng huling prestation, extinguish ang obligation.
Regardless kung paano nawala yung first and second item.
Walang indemnity na mag-a-attach in that case for the creditor. So, take note of Article 12.0 for another interesting codal provision. About Article 12.05, Attorney.
So, when the choice has been expressly given to the creditor, the obligation shall cease to be alternative from the day when the selection has been communicated to the debtor. Until then, the responsibility of the debtor shall be governed by the following rules. First, if one of the things is lost through a fortuitous event, he shall perform the obligation by delivering that which the creditor should choose from among the remainder, or that which remains, if only one subsists. If the loss of one of the things occurs through the fault of the debtor, the creditor may claim any of those subsisting, or the price of that which, through the fault of the former, has disappeared, with a right to damages. If all the things are lost through the fault of the debtor, the choice by the creditor shall fall upon the price of any one of them, also with indemnity for damages. The same rules shall be applied to obligations to do or not to do in case one, some, or all of the prestations should become impassible.
So, medyo mahaba itong article na to. Pero primarily, it pertains to the time when the right of choice belongs to the creditor.
Ito naman, kay creditor naman,
right
may
of
right
choice.
of choice.
So, in alternative obligations, the right of choice, sabi nga natin, as a rule, belongs to the debtor. Nevertheless, the debtor may expressly give the right of choice to the creditor. And these are the rules in case of loss before creditor has made choice. Kasi take note na si creditor...
So dito, ang situation dito, si creditor is expressly granted by the debtor ng right of choice. And the loss occurs before the creditor has made his choice.
Kasi titingnan mo kung na-communicate na ba niya yung choice. So kapag nawala or nagkaroon ng loss prior to the communication of the choice, these are the rules that would govern. First, when a thing is lost through a fortuitous event. Yan.
Yes.
So halimbawa si S, he obliged himself to deliver to B.
Si debtor.
Si debtor obliged himself to deliver to B, the creditor, let's say item 1 or item 2 or item 3 or item 4. So there are 4 prestations. If item 1 is lost through a fortuitous event, then the creditor can choose from among the remainder or that which remains if 3 of items are lost. Okay.
So kung nawala daw yung isang item through fortuitous event, mamimili ang creditor dun sa natitira. At kung isa na lang naman ang natira at yung lahat ay nawala through fortuitous event, di yung isang iyon.
Yan kapag fortuitous paano kapag ang pagkawala or ang loss ay due to the debtor's fault?
Yan, due to the debtor's fault. So, if the loss of item 1 occurs through the fault of S, B may claim item 2 or item 3 or item 4 with a right to damages or the price of item 1 also with the right to damages. So, mamimili pa rin si creditor kung dun sa kasama pa rin si item 1. Item 1, item 2, item 3, item 4. Kung si item 1 nawala through the fault of the debtor, so ang remedy ni creditor is for the payment of the value of item 1 plus damages. Kung si 2, 3, 4 ang napili niya, maalin doon. So, item 2 plus damages.
Yes.
Lagi may damages.
But when all the things naman are lost through the debtor's fault, take note na yung pangalawa natin, some lang, no? Yung nawala, or one, or a thing. Has been lost. But in this case naman, sa pangatlo, lahat na yung nawala through the debtor's fault. If all of the items are lost through the fault of the debtor in this case, then the creditor can demand the payment of the price of any one of them with a right to indemnity for damages. Pwedeng mamili si creditor kung alin doon ang gusto niyang pabayaran kay debtor with right to damages. But what if all of the things are lost through a fortuitous event? Attorney Uy?
E di syempre, the obligation shall be extinguished. Yan. All through fortuitous event, wala naman tayo magagawa.
Article 1174 shall apply in that case as regards fortuitous event.
Yes, so Attorney Meralit, are these rules applicable to personal obligations?
Yes, the foregoing rules are also applicable as regards personal obligations, and the responsibility of the debtor for damages depends upon whether the cause which has rendered the obligation impossible was due to his fault or not.
So whether the impossibility was due to the fault of the debtor or not.
Kung dahil sa fault niya, hindi liable for damages.
Ganun din ang rule, same rules.
Same guys. Okay, let's proceed with Article 1206.
Yan, facultative obligations naman to. So when only one prestation has been agreed upon, but the obligor may render another in substitution, the obligation is facultative. The loss or deterioration of the thing intended as a substitute through the negligence of the obligor does not render him liable. But once the substitution has been made, the obligor is liable for the loss of the substitute on account of his delay, negligence, or fraud.
So sige, interesting topic to, no? But we have to define first what is a facultative obligation. And take note, guys, that a facultative obligation is one where only one prestation, contrary dun sa alternative, two or more prestations yun. Pero dito, only one prestation ang meron tayo has been agreed upon, but the obligor may render another in substitution. So, isa prestation pero merong substitute na pwedeng i-render si obligor. So, for example, I promised to give you, Attorney Oy, let's say a piano. But I told you na I may also give, let's say, a television set as a substitute. In that case, can you consider that as a facultative obligation, Attorney Oy?
Yes. So, facultative yan kasi only one prestation is due, but the obligor may render another as a substitute. Sabi mo kanina, piano lang. Pero pwede ka din magbigay ng television set as a substitute.
So, if in that case, Attorney Oy, mawala yung piano, would I be liable for the loss of the piano?
In this obligation, only the piano is due. Hence, its loss through my fault will make me liable.
So, yung loss kasi dito, yung effect ng loss would be determined kung yung bang substitute ay
due? Alin ba dyan ang due and demandable? Yung bang substitute o yung original na prestation?
Kasi take note na meron din dito kailangan i-communicate. Kung kanina yung right of choice, ngayon naman, pagdating sa alternative obligation, dito naman ang kailangan i-communicate ay kung yung substitute ang gagawin. So, if it's before substitution, kung nagkaroon ng loss before substitution,
Yes.
then if the principal thing is lost through a fortuitous event, then the obligation is extinguished. Malinaw yun.
Yes.
Otherwise, the debtor is liable for damages. Yung sinasabi ni Attorney Uy na in the example we've given a while ago, kung nawala yung piano at hindi pa naman ako nakakapag-communicate ng substitute, then liable ako for damages because the loss of the thing intended as a substitute with or without the fault of the debtor does not render him or the debtor liable. Ano yung reason dito, Attorney Uy?
The reason is that the thing intended as a substitute is not due. Hindi ba kasi due? The effect of the loss is merely to extinguish the facultative character of the obligation.
So, for example,
Naging simple na lang.
Nagiging simple na siya. Example, si S will give B item 1 or if S wants item 2. Yan ang usapan nila doon. So, in that case, Attorney Oy, if item 1 is lost through a fortuitous event, ano mangyayari sa obligation?
The obligation of S is extinguished. Kasi nawala yung item 1 through the loss.
What
through the fortuitous event.
Yes, what if through the fault of S naman, yung pagka-loss?
Then, S is liable for damages.
What if item 2 is lost with or without the fault of S? Ano mangyayari?
S is still liable to deliver item 1. He is not liable for damages for the loss of item 1 as it is
Item
not due.
Item
For
2.
item 2.
Oo.
Okay, sorry.
Kasi in this case, yung item 2 na sinasabi is yung substitute. Eh, hindi pa naman nga nagko-communicate na ang gusto ay yung substitute.
Hanggang di pa nagko-communicate,
ang due pa din dyan.
ang due pa din dyan, yung principal thing. Yung kanina, yung piano. Pero once you communicated your right of choice, kung alin man dun sa kanila, at kung nawala yung substitute after communication or after notice, edi doon
liable na. Kasi nga, ang due na dun ay yung substitute. Kaya nga, dito sa pangalawa, yung after substitution, ito na yung effect ng loss. If the principal thing is lost, the debtor is not liable. Whatever may be the cause of the loss. Kasi take note, na-communicate na dito na ang i-deliver na ay yung substitute. So, kahit anong mangyari na dun sa principal, wala na tayong pakialam. Kasi ang pinag-uusapan na natin dito ay yung substitute, which is due. Yun na yung due dito.
Calling yung due and demandable.
Again, in this case, the principal is no longer due. If the substitute is lost, then the liability of the debtor depends upon whether or not the loss is due to his fault. Kasi kung yung nawala yung substitute dahil kasalanan niya, edi liable siya. Pero kung nawala yung substitute dahil sa fortuitous event, then hindi siya liable. Okay. Once the substitution is made, take note, the obligation is converted into a simple one to deliver or perform the substituted thing or prestation. The substitution becomes effective from the time it has been communicated. So, dapat i-communicate. So, can you give an example there?
So, based on the preceding example, if item 1 is lost with or without the fault of S, S is not liable for its loss since his obligation is to deliver item 2.
Kasi napili na niya na substitute ang i-deliver.
After substitution na to, ha?
After substitution.
So, dito naman, if item 2 is lost through a fortuitous event, the obligation of S is extinguished. So, if item 2 is lost through the fault of S, S is liable for damages.
Take note of that, guys. So, may effect talaga yung pag-communicate ng substitute. Kasi kapag nasabi mo na yung substitute ang ipe-perform, then it becomes a simple obligation.
Ang magiging due na dyan, yung substitute. Pero kapag before substitution, yung principal thing ang due. Yun ang mahalaga. Titingnan mo kung ang loss ba niya is due to fortuitous event or not.
So take note guys, kanina sa alternative obligation, kapag na-communicate na yung right of choice as to what prestation shall be due, nagiging simple din yung obligation kasi napili na nga kung anong prestation ang i-render, perform. Ngayon naman sa facultative, kapag na-communicate na yung substitute ang magiging due, then it also becomes a simple obligation kasi nga yun lang substitute ang nagiging due. From the debtor. So, can we give the differences or distinction between alternative and facultative?
As to number of prestations, ang alternative, meron siyang several prestations
na due.
But compliance with one is sufficient.
Sa facultative naman, only one prestation is actually due, although the debtor is allowed to substitute another. Okay?
Tapos, as to right of choice, kapag alternative, the right of choice may be given to the creditor or third person. Generally, di ba, sabi natin, debtor. Tapos, may exception kapag expressly stipulated, pwede kay creditor or kay third person.
Yan ay wala sa facultative.
Yes.
Bakit? Because the right to make the substitution is given only to the debtor.
Wala yung exception. Only to the debtor.
Hindi pwede sa creditor or third person.
Yes.
How about as regards loss through 427?
In case of alternative obligations, the loss of one or more of the alternatives through a fortuitous event does not extinguish the obligation.
Does not extinguish. Pagdating sa facultative naman, the loss of the thing due, may it be the principal before substitution or the substitute after substitution, then
it will extinguish
the obligation.
Tapos, as to loss through the fault of the debtor, kapag alternative, the loss of one of the alternatives through the fault of the debtor does not render him liable. Kasi pwede pang mag-comply dun sa isa. Where the choice belongs to the creditor, the loss of one of the alternative through the fault of the debtor gives rise to liability for damages.
Samantalang sa facultative, take note guys that the loss of the thing due through his fault makes him liable. Kapag fault niya ang pagkawala nung whatever is due,
whether it may it be substitute or the principal thing,
then he would be liable. But if the loss of the substitute before the substitution through the fault of the debtor, it would not render him liable. Kasi as yet, hindi due yung substitute na yun before substitution. How about nullity of prestation?
Yes, as to the nullity of prestation in alternative obligations, the nullity of prestation does not invalidate the others, and the debtor or creditor shall choose from among the remainder.
Yes.
So, hindi ibig sabihin na porque yung item 1, for example, item 1 is invalid, ibig sabihin 2, 3, 4 is invalid na. Hindi. The debtor or the creditor shall choose among the remaining.
Pagdating sa facultative, the nullity of the prestation agreed upon invalidates the obligation itself. So wala nang substitute na pag-uusapan dyan. Kasi to begin with, the principal thing na cover ng original obligation is void. And therefore, null and void na nga yung obligation. Pati yung substitute. Hindi na yun mag-matter. The debtor is not bound to choose the substitute in that case. Okay?